SJC-11918, adoption of Douglas.
Reminds me of the old baseball adage, can't tell the players without a scorecard. So you would begin and identify yourself and who your client is. It would be helpful.
May it please the court, my name is Craig Spratt, and I represent the 4 appellant children in this case, the 4 oldest children of the mother. The 2 are sons of one father, and 2 are sons of a different father. Children position is that the trial judge did not adequately consider on a going forward basis the needs of these children for contact with their birth parents, and did not adequately consider the sorts of factors that are laid out in RICO as to the needs of children who have spent a long time with their parents, as these kids did with their mother, or who are older children and whose identities, as a consequence, are tied up with the identities of their biological parents.
I cannot remember this, but is Douglas one of those 4 children?
Douglas is one of those 4 children. Douglas and Tom are the 2 oldest, and Brian and Mark are the 2 middle children.
It sounded like, and I have not studied the record, but it sounded like Douglas was, if I'm remembering correctly, somewhat in a class by himself. I mean, that there was specific issues about boundary difficulties of the mother with him. Is that?
Douglas is
I could be
perhaps in a class by himself, but I think the thing that is most significant about Douglas in terms of his uniqueness is that he is the oldest one, and he had the greatest amount of time spent living with mother. There are points that the judge makes about boundary issues relative to mother and him, but I think that that those are, in my way of thinking, overstated, and that the sex-related activity that the judge in his findings lays out only relates to such things as leaving the door open during sexual intercourse, things of that type that the mother did. None of those factors having to do with anything that like that plays any role whatsoever relative to father. And these children have all expressed an interest in seeing mother, expressed an interest in seeing their fathers, and I think that
including their father, the first father, who must be Douglas's father, and I forget.
Douglas's father and Tom's father.
Who's in prison, right?
He's incarcerated. However, the social worker for the department, the adoption worker, specified in her testimony that those boys enjoy seeing their father, that he tries to encourage them to make the right choices, that those boys like the visits, they're positive about seeing their father, and that they want to see him.
The DCF recommendation was that visitation take place.
That's absolutely correct, Your Honor. The DCF adoption worker testified extensively at trial that in favor of visitation for all 4 of the children that I represent, and no one testified against visitation by any of these children with any of their parents. And there were 2 therapists who testified who were therapists for 3 of the children, the 3 youngest of the 4 that I represent. And
the appeals court, however, suggested that the record reveals numerous instances where each of the 4 oldest children regressed or otherwise reacted very badly following a visit with the mother, including acting out sexually, bedwetting, nightmares, and throwing tantrums. So when you say there was no evidence to the contrary, no. I mean, it may be that the DCF recommended visitation, but wasn't there record evidence to support the judge in those regards as to visits, what happened to the children after visits with the mother?
There was some record evidence to that effect. It was also the case that the children acted out. These were children with very turbulent behavioral histories. They acted out badly after all sorts of different other kinds of triggers. And there was one case where the child didn't see his mother for something like over a year because she was incarcerated, and had a terrifically turbulent time during the time when he didn't see her at all. So I think it was overstressed that there was that type of connection. But even if that was the connection during the time, during that time, what we're looking at when we talk about visits is not just visits in the past, but visits in the future, when the children are trying to struggle with their sense of identity, particularly children who have, like the oldest two, who have very dim prospects for adoption and are not, as Vito talks about, trying to navigate between one family and another, but there is no family for them to navigate to. And the only people who have been parental figures in their life... Excuse me?
Are they in foster care?
The eldest is in a program, a
residential program.
Residential program. And he's still in the residential program. He's been in the residential program for a long time. And the other is in a foster home, and the proposed adoptive resources that the department put on the table were people who never followed through in any significant fashion, didn't progress through the various stages, and in fact, the judge himself had substantial questions and negative criticisms of those resources in his findings.
But didn't he adopt that plan?
He adopted that plan because that plan was not non-existent by the time of trial, but it was petering out to the point of near insignificance, and he wound up saying that, well, there could be, the department could recruit. But when you're talking about kids who have these tremendously turbulent histories or sexual acting out histories, et cetera, and are getting older and older, the chances that they're going to be adopted is just gets smaller and smaller and smaller. It just has to be recognized. And I think RICO talks about older children who have dim prospects for adoption and who need some kind of contact with their birth parents to help them understand who they are.
All right, thank you.
Thank you, Your Honor.
May it please the court, my name is Warren Yanoff, and I represent Father Jay, the father of the two eldest children. The issue that I want to focus on is the issue that the appeals court determined that my client had no standing, as well as that the mother had no standing to appeal. They used the case adoption of Malik, and quite frankly, if you read the adoption of Malik, this case complies with Malik, so that standing really is not an issue.
Because the termination, no judgment had entered on that at the time. I mean, this was all part of one proceeding.
That's correct. That, first of all, the judgment didn't enter, but even different, it's specified in the stipulation and in the colloquy, and the judge reinforced it, that there was a right to appeal the plan and visitation. And so there was a hearing. Malik came down after this case was decided. There was a subsequent hearing, and at that subsequent hearing, the judge reaffirmed that Malik didn't apply and that the issue of appeal to the plan and post-termination, post-adoption visits would exist.
Did this make a difference in the outcome? Because didn't the appeals court consider it substantively anyway, the visitation issue?
I don't think so. I think that what the appeals court, I think, did was conflate the issue of bonding as to the issue of post-termination visits. I don't think it addressed sufficiently the issue, as I've cited in my brief, the issue that there are other reasons beside whether there was bonding, and in this case, there was no bonding to another family, just that there was, because there was only few visits with my client, that in effect, that was sufficient to not have post-termination visits. As I've indicated, there are many reasons and that post-termination visits should exist. They should exist to help ease the pain of abandonment. They can add to that. And there's a sense of identity. It can help promote self-esteem. And when we take away without addressing those issues, especially with these two children who are not likely to be adopted, we have left a void. The judge didn't address that, and the appeals court, nor did the appeals court address that. I think it's a very important issue for this court to address, because we have post-termination, post-adoption visits, not just because we agree in an adoption plan, but these need to be addressed at the trial when that is contested to see if it is in the children's best interest. In this case, we have children who are saying, we want to spend time, we want to see our father, we want to see our mother. There are reasons. There was nothing that was disputing that. The adoption worker said clearly, we were going to resume visitation. That
Would
was
they
a-
be, was the proposal for supervised visitation?
Well, with my client, it would always be supervised,
Yes,
given the
yes,
situation.
yes, right.
And
How
I
about with the
believe-
mother?
I believe with mother, it was structured and supervised. The point is not whether that the way the visitation, but there should be
Right,
visits.
I understand.
Visitation can always be changed. We can certainly always go to a situation where if the children then decide that they don't want visits, they may not occur. But at least at the time of trial, we have a situation where they want visits, their wish, and the department wanted to do it. The fact of the matter is that we need the order. It's not sufficient to say, whoever the caretaker is, that they would do that, because in effect, as a result of the order, they have not seen their father. And I think we need to have that order in place, and that's why this has to be.
When was the judgment? I just can't remember the years. When was the trial in this
The
case?
trial was in 2013.
Oh, okay.
Well,
It's not that old at this point.
No, it was,
Not, well, it's actually 2015, isn't it? Yes. So
2
it's
years.
already
It's
been 2 years, yeah.
the termination, if you will, was October 1st of 2013.
And how old are the two children today?
One will be 15 in January, and the other one is 12 right now, 12 and a half.
All right, thank you.
Thank you very much.
Good afternoon. May it please the court, my name is Diana Cowie McDermott, and I represent the mother in this matter. Should the department prevail in this case, I don't see how that's actually a win. I don't see how the Commonwealth would win. There are 4 children in this case. They all want visits with the mother. However, based on adoption of Douglas, those 4 children cannot see their mother. How one can tell those kids, we understand you want to see your mother, but you cannot, is an impossible task. And it's one that does not make sense. These are kids that are of the age to understand. They are going to ask, why can't I have visits? They're 14, 12, 10, and 9. They want visits, but this court, the appeals court has denied them that right. The purpose of the termination proceedings is the focus on the children. It's not on the parents. The children have asked for visits. In order to fulfill that purpose, we should allow them to have visits.
Well, the focus is the best interests of the children.
That's correct. You're correct. The
Not
department-
necessarily what they say they want at any given time.
I'm sorry?
Not necessarily what they say they might want at age 9 or 8, right?
They have consistently said that they wish for visits. The department recommended 2 visits a year.
Clarify. Yes, it isn't just that they express it, but they have a right to express it, and that can be taken into account when considering best interests.
Yes, Your Honor. The 2 youngest children, there are 6 kids, the 2 youngest children are appellee. Directing the court's attention to the 2 middle children, they are in the custody, they are with a pre-adoptive home. That family has expressed a desire to keep the family together. Potentially, visits will occur. But the problem is the
But
two...
what do you mean potentially they will occur?
Well, they have expressed a strong desire to have the family together, so maybe...
I don't know what that means, though. What do you mean? That they are in
Well, they're
favor of the visitation with the mother, or is that what you're saying?
Well, what I'm saying is they testified at trial that they wanted the children, and they found it very important that the children and the family members have contact. The pre-adoptive family is a family member.
Right, but do they support the idea that the mother, that these
Yes.
children that they wish to
Yes.
adopt would visit with the mother?
Yes.
Okay.
So potentially, Ilona could take care of those two kids. As I say, it's the two oldest kids. Those two kids have no one in their life except for school administrators, the people at the residential.
So counsel, what are we supposed to do with the judge's findings that this is not good for the kids?
I would respectfully suggest that this case be remanded and that there are more findings with the aid of a GAL and medical experts to find out specifically what it is these kids want. And let's hear from the kids.
Well, that wouldn't help because that's not the issue, is what they want. I think it's been communicated fairly clearly that they want to have contact with their parents, but the issue for us is whether the judge properly made a decision based on facts that this was not in the best interest of the children. So the problem for you is showing how the judge made a mistake in making that determination.
The judge made a mistake because the findings are too sparse. They focus entirely on whether or not a bond existed. The court did not evaluate, would the children benefit from visits? What could the kids gain from the visits? Those kids are asking for visits. We should know why they want visits. These findings do not answer that question. The case should be remanded. The court should appoint a GAL, medical experts weigh in, and we should allow these 4 children, at least, to have visits with their mother.
Was this testimony before, was there testimony from the children or on behalf of the children? Or the children's expressed desires? Was this made clear to the judge below?
The court asked, are there any agreements? And the answer was no.
Children were represented by counsel at trial, weren't they?
That's correct.
So the children's counsel presumably could have expressed on their behalf that they really wanted to have visits with their parents.
That's correct.
Happen?
They did not, but all parties operated under the assumption, including the department, that the children want visits, and we support it. If you look at the department's closing argument, they say it is clear, the department says this, that the 4 children love their mother, and we recommend visitation.
Whose burden of proof is it on this question of visitation?
The department.
Okay. Has to prove by clear and convincing evidence that visitation is in the best interest of the children?
Yes.
Is that what they have to do?
Yes. If there's nothing further, I rest on my brief.
Great, thank you.
May it please the court, Attorney Robert McCarthy Jr., representing the appellee children. The appellee children would argue that the correct standard to apply when reviewing a visitation.
Those are the 2 youngest children.
The 2 youngest children, yes. The correct standard to apply would be whether the judge abused his discretion.
Wait, I'm sorry, but I thought nobody was questioning the judge. You're not challenging the no visitation, is that right? Am I right?
No, we're not. But we're saying that it wasn't shown that the judge abused his discretion when he made the visitation decision on behalf of the children. So
I'm just not sure who's opposing you at this point in
I
time.
thought the mother was.
the mother in her
There is,
brief,
I'm
the
sorry.
mother in her brief is opposing
But
the appellee children.
There's 6 children
There's
involved
6
here.
children.
And Mother's Counsel spoke of 4.
She spoke of 4, but there are 6 children, and I represent the youngest 2 children.
You represent children 5 and 6.
5 and 6.
I'm not aware that anybody's challenging that no visitation's going to take place in that, but maybe I'm incorrect about that.
I think it is in the briefs, not at oral argument, but in the briefs it is challenged as far as the appellate children are concerned too.
You're saying that children 5 and 6 do not want to visit with their parents?
Do not want to visit. They're not advocating for visits with their parents, correct?
And you don't want the question reopened?
We do not want the question reopened. We
As
don't-
to them.
As to the 2 youngest appellate children. The 2 youngest appellate children are 6 and 4. The 6-year-old just had a birthday in November. They have been in their pre-adoptive home since June of 2012. That at this
How would
point,
that happen if nobody is challenging that? How would what you fear happen, that this would be reopened? I mean, it's a settled question, isn't it?
settled question as far as what Justice
That
Sines.
children 5 and 6 don't have to visit with their parents.
That's what the judge ordered on, he didn't order it, he said it wasn't in the best interest of the children to have visits.
Okay, and nobody's challenging that. So how would the fear that you have that would somehow be disturbed come into being?
Well, she didn't challenge it here at oral argument, but in her brief, she is challenging the judge's decision
With respect to all of the children.
with respect to all of the children.
I see, okay.
So we're arguing that there was sufficient evidence to
I'm sorry,
support
I
the
get it now.
judge's decision that visits were not in the best interest of the 2 appellate children.
And they say no more than that, they just talk about themselves. You take no position as to whether or not the judge's findings and such were adequate with respect to the other 4 children.
No, it's just in regard to the 2 youngest appellate children, we're saying the judge's decision regarding the post-adoption and post-termination visitation was correct.
Okay.
And it was correct for a number of reasons. The mother didn't visit with the children regularly. There was a time in the summer of 2012 where the mother only visited with the appellate children once, then in the fall, another time. But prior to that, it was 14 months that the mother didn't interact or have any visits with these children, and they're young. The youngest appellate child came into care at birth, right after he was born. After the hospital, he went into care.
Did the record reflect whether or not the foster parents had opposed visits, had discouraged visits by the mother with children 5 and 6? And does the record reflect that she had scheduled visits and didn't show up to them?
No, there's there's no information in the record that was the case.
Following up on that, I had a note that the DCF recommended that visitation take place for all 4 of the older children. But was there any recommendation on DCF's part with respect to your clients?
No, there was not. No.
Okay.
there was
Not negative, not positive.
Well, there wasn't any
Okay.
positive information. I can say that. There was information. This trial lasted 7 days.
Yeah.
It was 6,000
No, but they
pages of
didn't recommend against, they just didn't take a position with respect to your 2.
Well, no, I
By
think it was-
inference,
it was
because they
pretty clear
weren't.
that, right, it was pretty clear that the visits weren't in the best interest of the children, the appellate children. Again,
Is there any sibling, I'm sorry,
Yeah, go ahead.
is there any sibling visitation?
yes, there is sibling visitation. There was
So you-
ordered 2 sibling visitations between all the siblings, all 6 siblings, and that's still taking place.
Did the mother, was she encouraged to make visits? I mean, was there a pre-adoption, or was there some kind of a plan in place that provided that there was a mechanism by which the mother could arrange for visitation with children 5 and 6?
Anytime a child is in custody, they're entitled to have visits. I think visits were open. She didn't visit. That was it. She visited during the summer of 2012.
So the whole matter of visitation with children 5 and 6 was essentially left open without any details as to how or when or whether it would be provided, She wasn't prohibited from visiting, but just never availed herself of any opportunity to visit.
She never availed herself. The judge did make findings that during the course of the proceedings, the mother only visited with the oldest appellee child 8 times and with the youngest 5 times.
Did she have scheduled visits with the older children? Or did she avail herself of the open format?
I'm not sure what she did with the older children. I'm just concentrated on the younger children, and I know she didn't visit regularly or often with the younger children at all. And
Now, she was in custody at some point herself, wasn't she?
she was in custody.
Was that during the
yes,
life of these
that is
2
true.
younger children, or was that before?
I believe I read that it was right before the trial that she was incarcerated.
So how much of her failure to visit can be attributed to the fact that she was not on the street?
Well, DCF regulations allow incarcerated parents visitations. I don't remember that coming up in the argument that she was prevented from visiting with the children. So we would ask that this court affirm the decision of the trial court and the appeals court in all respects in regards to the appellee children. If this case is remanded, we would ask that it not include the appellee children, who this March will be waiting almost 5 years for permanence. They came into care in March of 2011, and in March, the youngest appellee child is going to be 5 years old. We would ask that they get the permanence they deserve and as quickly as possible. Thank you.
Good afternoon. May it please the court. Lynn Murphy for the Department of Children and Family. So I would reiterate my brother's proposal, or
Which brother?
brother
You've
here,
got 3.
to uphold the lower court's decision. There was no error of law or abuse of discretion in any of the orders that the court had made. And if you look, you'll see I'm sure you've already looked, and there were extensive and very specific findings of fact and conclusions of law. This judge considered each of these children individually, all 6 children, and the evidence was definitely supporting those findings and conclusions by the court. They had significant special needs, and unfortunately, it took years to stabilize these children, and contact with parents had the effect of destabilizing them and bringing to the forefront these very troubling behaviors.
What do,
Go ahead.
what do we do about the fact that, as I understand it, consistently the older 4 have expressed their desire to have a relationship with their parents?
I don't believe the record supports that they consistently wanted visits with their parents. The record showed, in fact, particularly Tom was often ambivalent towards visits. And again, I have to check my notes because the names changed. Mark as well. There were times
Which, in birth
those
order,
would
which
be
ones?
the top 4, the 4 oldest.
I
not
know, but
the-
where do Tom and Mark fit in the top 4?
They are the middle
Tom is 2,
Tom is
right?
the 2nd oldest, and Mark would be the 4th, would be the 4th oldest. So
Okay.
on that top tier.
How is it available to these children who are pretty old and under some of the statutory law actually have a right to make their feelings known?
Right.
But if there is not even an order that contemplates future possibility in the right circumstances for visits for these children who have no, the 2 oldest have no placements, and the other ones, there seems to be okay. I mean, even there, the order could be in the discretion of the adoptive parent, which
That's
is at
right.
least
That-
in
and
order.
which is
How do children who don't always have a lifetime line to a GAL or an appointed attorney, and after an order here is entered, let's say the one you're looking for, which is different than the one that was proposed at the trial, how would they access that? They dial up?
Now, are you speaking of the 2 older
Well,
children?
let's just start with them.
Okay, now that's a good question, because now the older children are, first of all, the department would never give up on trying to find permanency for these children, and we never say,
Worried about that.
okay, so then, okay, so now, all right,
They're not going to, but I'm not
Oh,
worried about.
okay.
I'm worried
So-
about the contact that they seek in a structured, supervised environment, even if not now, even if not monthly, even if only as circumstances permit, maybe once a year in the future. How do they access that once there's a judgment and it's
very
all gone?
easily, because they still have counsel. Until a child is adopted, they still have counsel who represents them, and at any time. I mean, and remember, this is in flux. Any time that evidence is put on at that particular time, maybe everything's going very well then, and then the judge would say, oh, maybe an order should enter, or maybe it should not. But as soon as you leave that courtroom, that changes, and then the counsel for child can come forward. Say the department says, I disagree. The children want visits, but they're really acting out. This is causing, clinically, this is not our recommendation. But if the child's counsel disagrees, they go into court and say, the department's abusing its discretion. We want those visits. And then the court can look at that again, and in those circumstances that would be present at that time. It's only when the child's adopted that counsel drops off, and we don't have that representation.
So-
Is the department taking a different position now with respect to visitation than it did before the judgment entered?
No, the department has always been open to visits, but we didn't want an order. We didn't advocate for a permanent order, but the department was open to visits at the time of trial,
But
and
wasn't
it's
that
open to
part of
visits
the,
now.
well, it wasn't just open, you proposed them. Wasn't that part of your plan?
Well, the trial counsel did use those words, but it was not part of the department's plan. But even if it was, that's really immaterial, because it doesn't matter what the department says.
Well, you're the department, and I think the question was, have you changed your position?
No,
So-
no, the department has always been open to visitation if it's in the best interest of the children. And again, at the trial, the social worker did testify at that snapshot in time that if the kids wanted visits and it met their best interest, the visits would take place.
Okay,
next year it
so
might.
if 6 months from now, one of the lawyers for children 1, 2, 3, and 4, or 4, goes back into court and say, Judge, could you reconsider? Could we have visitation now? Would the department take the same position as taking on appeal?
Well, I don't know the current situation of the children. And again, this is a complex case. So if our social worker said, everything's been great since trial, the kids are very stable, and I'm not concerned about these visits destabilizing those children, then the department's position we would say, certainly visits are appropriate. But it depends, and this is what makes it very tricky. You have very needy children whose state of needs and their ability to visit change. It's a very complex and emotional issue.
How would that even happen if they're not seeing their parents? How would it ever come up that the situation is now different enough that visitation could be reconsidered if they're not seeing their parents?
So how could...
How would that, I mean, you say that the children are stable right now, and I'm saying that being the case, if they're not seeing their parents now, how would a changed circumstance ever happen that would suggest revisiting the visitation order?
Absent an order.
Yeah.
Well, don't forget, the purpose of the order, purpose of a post-adoption visitation order is to preserve a significant existing bond that existed at the time and benefits the child. So if that child isn't mentioning anything about visits, and is certainly not...
Who would the child be mentioning it to?
Their therapists, the foster parents, or the social worker. There could be any number of clinicians.
But they were at the time, and the department was advocating for it, and now you're not. I'm just lost on that.
We're not, how can I put this? The
A
department,
recommendation below, as counsel had said?
council did use the word recommendation, and you can, even if you look at it in that respect, okay, the department, say we did recommend visits, and we wanted visits. It was not part of our plan, but just say it was. The trial court didn't have to order those visits based on what the social worker said, given the evidence of how unstabilizing those. There was an abundance of evidence.
Isn't there, sorry, but it's been presented as an all or nothing. We either decide no visit order, period, or visitation. But many of these circumstances, I don't know most, but certainly the ones that I've seen here, provide for the opportunity. And that is crucial to permit a child to access an opportunity. So you don't have to retry and open and show a change. It's just the contemplation. If the department recommended that circumstances could be such that in the future, or in the case of the younger ones, say in their discretion of the adoptive parents, or even in the middle ones in the discretion of those adoptive parents, but it's not that they're just saying, okay, twice a year. That's not how these go. It's just that it's within the structure. I think the first one, veto, I think that was probably ordered. Just within that contemplation, so that you have the right to seek it, not to establish the right.
Right, well, right, but they can, certainly, the two oldest children, I think everyone can agree, for the four youngest children, they're going to be adopted, they have pre-adoptive families, those families will have discretion to decide in the best interest. That is an easier issue.
Don't you usually put that in an order?
No, absolutely not. The discretion,
that it
Alona
says, visits in the discretion of the adoptive family. Haven't I seen that?
No, that doesn't need to be in an order. That's
Haven't I seen
assumed.
that?
Once the pre-adoptive parents becomes the parents, we have a presumption that parents act in the best interests of their children unless proven otherwise.
Decide other than what the judge decided. If the judge thought it was a bad idea, they could say, well, I don't agree, and they're my kids now.
They certainly can. They certainly can, absolutely.
Right,
And that's the whole purpose and point of the discretion of.
So there's no judgment? I'm just hallucinating? That's not in part of a judgment that can occur?
Judge leaves it to the discretion of the pre-adoptive parents.
In the judgment itself?
If they don't order post-adoption visitation, one can assume, I can't remember now if this
Okay,
order said.
That's not what I'm asking. All
it's-
right.
Okay,
I don't wanna belabor it.
but just to be clear, if a foster parent were to decide to bring the children to the mother, they would not be in violation of the court order.
Absolutely not.
So what the court said is, I, the court, am not going to order that.
That's right.
But
That's a minimum.
But it doesn't, it's not an order that bars such
Absolutely,
visitations. It
absolutely.
simply is an order that does not
Apologize.
obligate
I
it.
didn't understand that. The order would be a minimum, and even there's cases where a judge might say, well, I'm going to order one visit a year, and the foster parents who become the pre-adoptive parents, those kids can visit every month, every day. That's a minimum threshold when an order issues.
But in this case, the judge said it is not in the best interest of these children to visit.
Absolutely.
So even with that finding, not an adoptive parent, but a foster parent could say, I think it is, I'm going to put them together?
Yes, because once the foster parent becomes a pre-adoptive parent.
No, not when.
Oh, at what point? do you
Foster
mean?
parent,
Well, if the
foster
depart-
parent.
then it's the department, it's not the foster parent. Then the department has the discretion to determine what visits are in the
You don't have
best
to go
interest.
back to the judge for permission.
No,
even-
we have discretion. So in other words, the department's going to act as the parent until such time as a parent
Yeah.
takes over. And then that discretion is with the parent, whether it's the department, whether it's the pre-adoptive parent who will then become the parent.
So the court did not bar such visits, he simply did not order it.
Exactly, absolutely did not bar the visits, just found, given the evidence, that these visits would not be beneficial to the children in any way, and then there were no bond, except for the oldest child.
Just one last question. Are you adhering to the position that the mother and father don't have standing?
Yes, because the post-adoption visitation is a right of the child, and once that decree enters terminating parental rights, then the issue is for the child to assert. And in this case, it did, so we didn't have a problem because the children went on to argue that the visits should have been ordered. But there was, as you know, the appeals court did not see it that way. So I would, again, thank you for your time, and we hope that you will affirm the decisions of the trial court in all respects.
Thank you.
Thank you.